argument in this case. Roberts pointed out that the Supreme Court has actually not used or cited Chevron like since 2016. I've been quoted as saying in the Supreme Court, Chevron is kind of like Lord Voldemort in the Harry Potter story, he who shall not be named or talked about. So what? So what if we overturn Chevron? It wasn't being used anyway. That's your question.
Yeah, I guess two reactions to that. One is, even if the court had not sort of deferred to an agency interpretation since 2016, as was noted in the opinion, lower courts continue to rely on not only the concept of deference, but also just the framework, the two-step framework, as a way to approach and consider questions of agency interpretation. And to the extent, lower courts were perhaps not using all of the tools in the toolbox of statutory interpretation, as the court has explained in the Loper Bright decision, I think this will be a change in how those courts, and in particular the DC Circuit that gets so many agency review type cases, approaches the question. And similarly, I think that it will also affect how my former colleagues at the EPA General Counsel's Office and others across the government advise their internal government clients on the viability of various statutory interpretations to support, the policymakers' objectives. And, I think one potential effect of this decision will be, what proposed rules will we never see issued, or what proposed rules will look different because the agency the EPA or any other agency no longer feels confident about relying on deference to support perhaps a more creative or novel statutory interpretation, and feels like it should keep its interpretation more firmly grounded to the statute. So those are two ways that I think this decision could impact both judicial review and what rules we see from agencies.
So, Senator, this is sort of my opposite point of so what that David responded, writing in Law 360 today. Commentators had this. The title of this was "In Memoriam: The Modern Administrative State," and of course the article says pretty much this is the end of the modern administrative state if you combine Jarkissi, the decision, as well as Loper, the decision. Do you agree?
I agree that there's a lot of headlines right now that are predicting the demise of the regulatory state, and I think that it's a risk, right? What the court is doing between Loper Bright and then in Jarkissi, and for our audience members, as in the SEC versus Jarkissi case, the court says that there is a Seventh Amendment right to a jury trial that would attach to an agency's kind of internal kind of tribunal proceedings. So, where an agency oftentimes brings enforcement actions in-house, the court says, well, if you're doing this in-house, you don't get to escape the Seventh Amendment jury trial, and therefore upsetting kind of a lot of the structure that has been in place for agencies engaging in their enforcement proceedings, right? So you've got Jarkissi on the one hand that is really reshaping administrative tribunals in the interior space. And then you've got Loper Bright that is creating this deregulatory risk. But I will say, so it is true, right, that there is a lot of movement right now. At the same time, I think it is worth understanding that there is a lot to be written, or there's a lot of future out there that has to unfold, because getting rid of Chevron, and I mentioned this earlier, getting rid of Chevron alone doesn't mean, okay, it's not an automatic win for a deregulatory impulse. You have to have, as David mentioned, you'd have to have an agency's kind of responding maybe to the opinion and being less cautious. It matters what the agency is doing. It also matters what the judges are doing. Who is taking a de novo type review of statutory language is going to matter more in this Loper Bright world. And given that the nature of the ideology of judges maybe has shifted a bit more conservative in the last number of years, maybe that's part of the concern. But I think it's worth understanding that removing deference to agencies alone doesn't mean the end of the regulatory state. That said, the court is engaged in a number of opinions where the court's vision, or at least the sixth justice majority, does seem to envision a structure of government where there's more tightly cabining of the lanes of Congress, the lanes of the executive branch, and ironically, a broadening, I would say, of the lanes of the judiciary.
All right, so I'm going to use, this is for you, Kirti. I'm going to use where Senate took us back to you describing the opinion. So relevant, I grew up in Detroit during the Motown area, so I am clearly an Aretha Franklin fan. Remember Aretha Franklin, RESPCT there. So you mentioned a form, I don't know if you would call it deference or respect. Roberts cites Skidmore 5 times during his opinion. So do you think if you're at the Department of Justice, you do a word search now, find and replace everywhere it says Chevron, you insert Skidmore and you keep going? Is that how it's going to work?
I don't doubt that something along those lines will be happening. I think it's a little bit more complicated than that for agencies, which is, on a superficial level, Skidmore is a fact-specific, multi-factor, broadly worded test, whereas the Chevron deference framework was quite clear, whatever else you might think about it. And the other thing I think that agencies are going to be grappling with is the amount of emphasis that the court puts on the long-standing nature of the agency's interpretation, which sort of mirrors moves that we've seen the court make in many other cases recently, including administrative law cases, in particular, the cases outlining major questions doctrine. And I think that it creates some incentives that are actually akin to the ones that the court claims to be wanting to solve. So you could see an administration coming in and seeing a longstanding regulation that it disagrees with and changing the interpretation, or offering a sort of carve out from the interpretation, kind of chipping away at the earlier interpretation so that by the time it comes back to a court, there's no longer a longstanding interpretation. I think agencies are also going to have to do some deep thinking about how to fit their longstanding interpretations into the court's understanding of what a longstanding interpretation is, which is, again, a similar analogous debate that's playing out in other areas of the court's jurisprudence. So you can think of it as analogous to something like Bruin and what historical analogs are and how similar does something have to be. And a lot of federal statutes, including the environmental statutes, are iterative. And so they expressly kind of anticipate that agencies are going to be addressing new problems as they come up. And so agencies are going to have to do some work to explain why, even though the factual setting is new, the interpretation is old and deserving of respect under the sort of factors that the court has emphasized in this decision. So I think they'll obviously try, agencies will try to get as much out of this opinion as they can to make their regulations sticky as possible, because obviously they would issue a regulation if they didn't think it was worth doing and they wouldn't want it to be immediately overturned. But I don't think it's as simple as just invoking Skidmore as some sort of talisman.
Going in building on what you just said, this is back to you, David. David, I think during your EPA general counsel era, you had a hand in the Supreme Court's decision in West Virginia versus EPA, and that's a Roberts decision, which announces or maybe invigorates the major question doctrine. How does that fit? How does that fit now, Loper and West Virginia? What does that mean for administrative law?
Yeah, I think the interplay of the major questions doctrine with the holding in Loper Bright is something that we'll have to pay close attention to. In that case, where we were defending the Affordable Clean Energy Rule, and the DC Circuit ruled against us, we were advancing, the concept of the major questions doctrine, perhaps without using that exact terminology, but the concept that Congress needs to speak clearly when an issue is of vast political or economic significance, I think takes on a greater role now that the agency cannot point to sort of a reflexive deference standard that it's owed, that sort of it's another indication from the court that lower courts and ultimately, the court itself will use all available tools of statutory construction to figure out Congress's direction to agencies. And if there's not a directive to agencies, sort of bringing it back to the facts of the case here, if there's not clear authorizing language that vessels in the Atlantic can be charged for observers, where there is clear authorizing language elsewhere in the statute about vessels in other places being able to be charged for observers, that's not a delegation of authority to the agency to act to fill the gap. That is rather an indication that Congress intended to withhold that authority for that particular circumstance. So I think when you combine the two doctrines, if you get to and again, I'll caveat this by saying we're still seeing major questions play out in the lower courts. Lots of parties are raising it as sort of an additional argument, but there have not yet been sort of a significant number of cases actually applying it in a way that we can say this is how the major questions doctrine will fit in future cases. But it's something that interplay is something to watch, and I think it gives agency general counsels probably some additional heartburn, because it will require them to be very, upfront with their internal policy clients about what statutes authorize and what they don't, and how risky particular interpretations that expand an agency's authority would be when it reaches this court.
Then there's other forms of deference out there, right? There's this hour deference that talks about, deference to regulations. Is that still valid, or does it go away after Loper? What's the status of, regulatory deference?
So Loper Bright only deals with Chevron deference. So it only deals with the kind of deference that agencies get when there's ambiguity in the interpretation of a statute, right? You're right. There's another major form of deference out there that agencies have gotten over the years. It's gone by different terms. Seminole Rock deference, because it was born out of a case in the 1946, Seminole Rock versus Bulls. Our deference, which is a 1996 opinion from Justice Scalia. And then most recently in Kaiser versus Wilkie, that's a 2019 opinion that Justice Kagan wrote. And there, Kaiser or our deference was actually, the question there was whether our deference should be overruled. And there, which was a very different court than what we have today, there the court didn't have the votes to overrule Kaiser or overrule our deference. And so instead, Justice Kagan cabined it. Ironically, and I should say that our deference is the kind of deference that agencies get for ambiguities in their own regulations, and it was a very reflexive form of deference under our. It had been shaped some by the court in the last 10 years, but it was a strong form of deference. And so when Kagan and the court was tasked with deciding whether to overrule our deference, they didn't. They cabined it and what I was about to say is it's ironic because the way they cabined it was actually to structure our deference so it looked a bit more like Chevron. So the answer to your question is technically no. Loper Bright doesn't undo our deference or Kaiser kind of deference, but we see now that the court is really skeptical, right, of deference. And so I think what we're going to start to see the lower courts do is actually take the admonishments in Kaiser probably more seriously and actually start to kind of push the bounds of the kind of deference that is given for an agency's interpretation of its own regulation, which is to say, kind of shrink it, maybe read Kaiser more aggressively than they had before in terms of its cabining effect. So I think there will be spillover effects from Loper Bright into the other forms of deference, but technically the Kaiser framework is still intact. Eventually, probably the court, I would imagine, will look for a case where they can clarify that Kaiser looks more like Skidmore than Chevron. And then we'll be back in a Skidmore kind of world, which, by the way, Justice Kagan in oral argument said Skidmore means nothing. It's always meant nothing. So
I'm going to ask, just the way in a closing minute, Kirti, if you could say anything quick about, you said that Chevron, or excuse me, Loper does not revisit the Chevron decisions, but what do we do with corner post then? Corner post that says that the APA statute of limitations, which we thought ended at 6 years, now seems to be longer than that.
Yeah, a tough question to answer in less than 30 seconds. I think I suspect if people are attending this, they're most interested in the environmental statutes. Most of those statutes have statutes of limitations provisions that are distinct from the statute of limitations provision at issue in corner post, in that they expressly run from the time of the final agency action rather than from when the claim accrues, as was the issue in corner post. So there are many regulations or past agency actions in the environmental arena that won't be affected by corner post. For other areas of law that are not so lucky, the sort of coming together of corner post, Chevron, the major questions doctrine, is that there is a significant possibility that older agency actions, settled regulations, can be subject to new challenges under new rules of the game, sort of the post Chevron world, the new major questions doctrine, and a new judiciary. So I think there's a potential for real instability there. And we've definitely already seen public statements from groups that are disinclined to like regulations, that they are seeing this as an opportunity to challenge them.
I think for the audience, what you've seen by our expert panel is that interpreting Loper requires some knowledge of where the case was beforehand, but now it fits into a matrix of not just this term, but as David has already talked us through older cases, West Virginia, Senate talking about what happens now in another form of deference, and now finally Kirti leading us through corner post. So to be good in this area, to understand, to be able to advise clients, all of these meld together. And I think all of us agree that there's going to be a lot of litigation in all these as we figure out the parameters of deference, but also figure out the parameters of the Administrative Procedure Act. And on behalf of the entire audience, for our expert panel, thank you. You've been superb. By the way, none of these questions were rehearsed in advance, and they came from the audience. So I very much appreciate the audience involvement. We didn't get to all of them there, but we got to most of them. And with that, I turn it back over to you.
If you enjoyed this content, please be sure to check out the full presentation, now available on demand at alicle.org. Please be sure to follow and subscribe to ALI CLE on LinkedIn, YouTube, and Facebook to see more content like this and to not miss out on CLE opportunities.